The Supreme Court issued a decision denying emergency review to a case which sought to immediately block a New York controversial rifle and shotgun permit requirement. That denial caused a dismissal of a case in the Second Circuit, and now the lower court in this case is looking to do the same. So let's talk about what is happening. Now, really quick before we jump into this video, I just want to ask you guys, if you want to support the channel for free, please consider subscribing to the channel. I know that YouTube loves to unsubscribe people, so also just double check to make sure you have not been unsubscribed. Click the notification bell, turn on all notifications, and then just drop a positive comment down below, because that helps to ensure that YouTube sees that there's, positive interaction on this video, and it signals the algorithm that it should share this type of 2A content to more people and share other videos from other people to you guys as well. Now, as I mentioned in the intro, in this video, we're going to be discussing a very important rifle and shotgun permit case, which was recently denied emergency intervention by the United States Supreme Court, and as a result, it was thrown out by the Second Circuit. This case challenges New York City's permit requirements that must be met to possess a rifle and shotgun within the city. The case we're going to be talking about in this video is called Schroer versus the City of New York. The emergency application in this case recently went to the Supreme Court, but the case was then denied emergency review. The Supreme Court denied emergency review at that time because this case and the decision was still pending in front of the 3-judge panel in the Second Circuit, but after that denial by the Supreme Court, the Second Circuit was then free to issue their decision. However, the Second Circuit did not look at the case at all. They didn't review the merits of this challenge, but instead, they took a different approach. Instead, the Second Circuit found that this issue was now moot and then decided on their own to throw the case out. This has now set the case up to potentially be completely thrown out by the lower court as well, and could set up a new petition to the Supreme Court because the Second Circuit decided to not review the issue, but instead to just moot the case. Now, this case involves a permit scheme that is in direct defiance to what the Supreme Court said in their recent Bruen decision. The plaintiffs argue that under Bruen, the Supreme Court struck down a similar application process that was purely discretionary. The Supreme Court found in Bruen that there was no historical support for May issue CCW permits, and now the plaintiff in this case argues that there is no historical support for a May issue firearms possession permit. So one permit deals with concealed carry and carrying those types of firearms, but this permit here deals with the actual ability to purchase and possess them. This case was brought by the plaintiff Joseph Schroer, who challenges the constitutionality of the New York City discretionary licensing scheme for the purchase and possession of those rifles and shotguns. Now, on review, the federal district court granted a permanent injunction against a provision of the licensing scheme that requires individuals to prove that they are of good moral character. That, of course, was a huge win, but the city of New York was not going to let that stand. The city appealed the permanent injunction up to the horrible Second Circuit Court of Appeals. New York also sought a stay to be put in place on that permanent injunction while the case was appealed and moving forward. The Second Circuit, of course, got that stay from the Second Circuit, and then an emergency application was filed to the Supreme Court specifically, and then it went to Justice Sotomayor. However, the Supreme Court denied the emergency application. They denied emergency intervention in this case, and once again, the Supreme Court stayed true to their approach that they did not want to get heavily involved in interlocutory cases. But the denial of that application by the Supreme Court had huge ramifications for this case. As a result of that denial, the case then moved forward to the Second Circuit, and essentially the Second Circuit was set to determine if they wanted to proceed forward in this case and look at some of the arguments about the constitutionality of this permit process and the good moral character determination. Now, after listening to those arguments, I predicted that maybe the Second Circuit would in fact take the easy way out and find that this case was moot and not rule on the constitutionality of these issues. And that's exactly what they did. The Second Circuit mooted the case and threw it out. In the order, the Second Circuit stated that we now hold that because Schroer has been granted the very relief he sought, the case before us is moot, and we lack jurisdiction to hear the merits. They went on to state that there is no indication that the city granted Schroer's rifle and shotgun permit to intentionally moot this case, or even that its action was related to this lawsuit. Now, there are two main considerations that you can use and two approaches you can use to overcome the mootness argument, like what happened in this case. One of those being that the party tried to moot the case intentionally, and the other that is even if the issue is moot, that the injury is likely to recur. Schroer argued not only did the city intentionally grant his permit in 2024 to moot the case, but also that the city still has power to revoke or deny his renewal of this permit whenever they want. The Second Circuit actually just said that they believe the city of New York that they did not intentionally grant the permit to moot the case, and they believed that the city of New York would not retaliate against Mr. Schrower and that they would automatically renew his permit when needed. And based on that, the Second Circuit threw the case out. Now, the district court in this case recently held a status conference for the case and then dismissed the city's original request to dismiss the case, but now a new motion to dismiss has been submitted based on mootness, and the question is whether or not the lower court is going to follow what the Second Circuit said. The plaintiffs recently filed their brief opposing the new motion to dismiss, and in their brief they argue that the complaint did not seek an order directing the police commissioner to issue any license to plaintiff. So the city's voluntary issuance of a license to plaintiff provided him with none of the relief sought by his complaint. There continues to be a case in controversy between the parties. The city's voluntary cessation of its enforcement of the challenge rules does not automatically render this case moot. While the Second Circuit held that the issuance of a rifle and shotgun license mooted plaintiff's claims for injunctive relief, it was based on the court's assumption that the renewal of his rifle and shotgun license is automatic under the New York City administrative codes. Every handgun license in New York City expires 3 years after its issuance. Plaintiff's handgun license will expire by operation of law in March 2027, meaning that the plaintiff will again be subject to the enforcement of this law. Without a court order or the pending litigation, the city is free to return to its old ways. So here what the plaintiff is arguing that not only did he not get the relief that he was asking for, but there is still the potential that the New York City there could just simply decide after 3 years to revoke his license or not renew it. Now, in opposition, New York argues that Schrower has no standing in this case to challenge the new law and that he has received the sufficient relief by receiving those permits that they issued to him in 2024. They argue, therefore, this case should be thrown out. Now, Schrower argues the Second Circuit really sidestepped the true relief that he was asking for by saying, well, you got a permit, so you've got the relief that you wanted. But he says that what he really wanted was the enforcement of this law to be permanently enjoined. He just simply wanted the law to no longer operate as it is. That is the type of relief that he wanted. He did not want a license. He didn't argue for the issuance of a license. He argued for the law here to be enjoined. So this new attempt to dismiss the entire case now in the lower court might push the plaintiffs again to seek Supreme Court emergency intervention. The Supreme Court's initial denial had ramifications on the Second Circuit, and the Second Circuit then felt comfortable enough to not review this issue, not review the constitutional questions, but instead moot the case and throw it out and not review it at all. And now the lower court is faced with the same issue. The lower court could align with the Second Circuit and find that the case is moot. However, this lower court is the same one that found that the good moral character determination was unconstitutional, Bruin violated the Second Amendment. So it's going to be interesting to see what the lower court does. Right now, there's arguments about, did Mr. Schrower get the relief that he asked for? Is him getting this permit in 2024 after this lawsuit, was that done to actually moot the case? Is that type of relief that he wanted? Or should he be given something else? Is there still a live and active case? In my opinion, there is still a live and active case. His permit does not automatically renew. I believe that the city of New York has actually mooted this case intentionally because New York is known for doing that. They've done it in multiple cases, even once in front of the Supreme Court. So I think there are some valid arguments for why this case needs to proceed forward and why it should not be thrown out by the lower court. But we're going to see how this develops and ultimately what the district court decides to do. But this is one of those perfect cases that shows what are the ramifications when the Supreme Court does not get involved on these issues and how lower courts like the Second Circuit can feel emboldened to then just do whatever they want and moot a case like this and not actually review it at all. So as we get more information, as this develops, I will let you guys know. Also, if you like this video and you'd like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm and it signals to YouTube that you guys see value in these videos and in this type of two-way news. But as always, thank you all for watching. Don't forget to like, comment, and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.